You just got arrested for DUI, and the officer made it sound like your case is already lost. But in Oklahoma, that might not be true anymore. I'm John Cannon, criminal defense attorney here in Oklahoma, and a recent change in state law just gave you a new opportunity to challenge how your arrest was handled. In this video, I'll walk you through exactly what the law says and how it could give you leverage if you know how to use it, so you can avoid pleading too early, fight smarter, and protect your license, your record, and your future. Senate Bill 54 created a category called Aggravated DUI. And in Oklahoma, Aggravated DUI can be filed as a felony, even for someone who's never had a DUI before. But aggravated doesn't mean extra drunk. Aggravated means DUI plus one of the aggravating factors listed in the new law. So think of it like this. There's the DUI claim, and then there's the felony upgrade claim. Those are two separate battlefields. And this is where your advantage starts, because your whole case can hinge on one question. What exact box are they checking to call it aggravated? The big idea, the felony is a checklist. Here's leverage point number one. Senate Bill 54 turns the felony into a checklist. That matters because it means the state can't just say, this feels serious. They have to say, this specific aggravated factor applies, and then prove it. Common aggravating factors people hear about include things like a high blood alcohol level, speeding over a specific threshold, a minor passenger in the vehicle, a reportable crash, reckless driving, eluding or fleeing law enforcement, certain traffic violations tied into the story. You don't need to memorize the statute word for word to benefit from this. You just need to understand the logic. Felony is not automatic. Felony is an upgrade. Upgrades require proof. Leverage point number two. Most aggravating factors are arguments. This is the part most people miss. A lot of aggravators are not just facts, they're arguments. Let's use speeding as an example. There's a massive difference between he seemed like he was driving fast and here's reliable proof he crossed the speed threshold. In real cases, speed claims come from a method. Methods have reliability. Reliability has documentation. So if the felony upgrade is based on speed, your attorney will care about questions like, how was speed measured? Is the timeline consistent? Is the report specific or vague? Does dashcam footage match the claim? Is the speed clearly above the threshold or borderline? Was the calibration done properly? Because borderline is where leverage appears. Same with the crash. People hear crash and think, well, that's aggravated, but crashes happen for all kinds of reasons, even when nobody's impaired. So it becomes questions like, who actually caused the accident? What does the report actually say? What do witnesses say? Does the physical evidence match the story? Again, argument, not magic bullet. Same with reckless driving. Reckless isn't supposed to mean I didn't like your driving. It's a legal concept that typically needs a clear factual foundation. Here's the point. Senate Bill 54 forces precision, and precision creates pressure points, because the more specific the claim, the more it can be challenged when it's overstated. Leverage point number three, mandatory consequences change everything. Now, leverage point number three. Senate Bill 54 brings serious mandatory consequences in aggravated cases, including mandatory jail time. That changes the negotiation math because the difference between a standard DUI path and a felony aggravated DUI path isn't small. It can be the difference between serious problem and life-altering problem. So the upgrade becomes the most valuable piece of the case. If the upgrade is strong, the state will push hard. But if the upgrade is weak, that's where defense leverage grows. Not because anyone is being nice, because nobody wants to gamble a felony outcome on a shaky upgrade. Let's make this real. Scenario number one, the speed hinge. You're driving home at night in Oklahoma City or Tulsa. You get stopped. The officer says you were speeding. Then the DUI investigation starts. If the felony upgrade is based on speed, your case may hinge on one thing. Can they prove you crossed the thresholdability cleanly and reliably? That single point can be the difference between misdemeanor track and felony track on a DUI. Scenario number two, the family passenger hinge. You have your kid in the car, you get stopped, and a DUI allegation starts. That is an extremely serious situation, and it can trigger the upgrade. But again, it's a checkbox, and checkboxes still require proof, documentation, and a clean timeline. Scenario number three, the minor accident hinge. There's a small accident, nobody is hurt, and you think it's an insurance issue, but it becomes a report. Now the state may claim the incident as the aggravator. And this is where people get blindsided because they think it was minor. Senate Bill 54 doesn't care how it felt, it cares what aggravator is claimed and whether it's provable. Here's some quick myth busting. Myth number one, if I'm a first timer, it can't be a felony. Not necessarily. Under Senate Bill 54, certain first-time scenarios can't enter felony lane if the upgrade is claimed. Myth number two, if they call it aggravator, it's over. Nope. Aggravated is a claim. Claims require evidence. Myth number 3. If you fight the aggravator, you're admitting the DUI. No, cases are fought in layers. The DUI claim and the upgrade claim are separate battlegrounds for your attorney to fight. If you remember nothing else from this video, remember these 3 questions. If the state is pushing aggravated DUI, ask, what exact aggravator are they using? Not aggravated DUI in general, which box are they trying to check? Number 2, what evidence supports that exact box? Reports, video, timeline, measurements, specific details. Question number 3, what changes if the aggravator fails? Because that tells you what the upgrade is worth, and what it's worth tells you where leverage lives. Senate Bill 54 is tougher, no question, but it also creates a structured felony upgrade with specific triggers, and anything structured can be tested. So remember this sentence. Senate Bill 54 made aggravated DUI a felony, but it also made the felony a checklist. And if they can't prove the checkbox they're using, the felony upgrade is in trouble. If you like this video and want to see more, then check out my next video where I go in depth into Oklahoma's new law. See you over there.